guys, it's me, Sylvia. How you guys doing? I am here. As promised, I have some footage for you guys. Quite a few footage the from yesterday. Remember, yesterday I was off, so I came in and I got a couple of treats. I got a couple of video coverage, so I'm gonna play that for you guys as I take care of the ones that's going on today because I'm getting footage for today, and this is for yesterday. Okay, let me go ahead on and put on my just to get a chance for you guys to see the individuals that are here part of the case. How's everyone doing? Let me say hello to the folks in the chat. Hey, pretty brown eyes. Hey, Wanda. Hey, So Mahogany. Hey, Nosy Rosie. Hey, Trissy. Hey, Black Beauty. I hope everyone's doing well. Um, So I'm gonna go ahead on and start playing this footage from yesterday. And the great thing is, let me tell you what he did. He cut them up into little small pieces. So this helps me to avoid the coverage of the what do you call it? The hardship. Hey Derek, good morning, Derek. Good morning, Sierra. All right, let's go ahead on and show you guys some stuff and give you guys something to watch, okay? Let me pull it up for you guys. And I got some sound. Let me know if you can hear this sound. Hold on. Let me see if you guys hear this sound. I'm trying to do some sound effects in the background. Let's see if you guys hear this. Did y'all hear the thunder? Did you guys hear the thunder? Did y'all hear it? Did y'all hear the thunder? How about this? All right, now we're cooking with grease this morning. We're cooking this grease, and I decided to start doing some sound effects in the background for you guys. So, all right, let's see if we can hear this machine gun going. Hold on.
Holy crap!
All right, let's go. Let's get going. So, you guys, I'm gonna be playing with these sound effects, right? I'm gonna be playing with these sound effects. I am. Hey, Callie, good morning. Good morning, Kay. Good morning, Trissy. Good morning, Perspective. Good morning. I think I said good morning, Black Beauty already. Good morning, everybody. All right, here we go. Let's get going, okay? Okay, let's get going. And the one I recorded with me saying my word, it didn't work. It didn't work at all. It didn't work at all. What I'm gonna do is when I get ready to play those people in the background, when I get ready to show the jurors thing, I'll put some sound effects in the background. Okay, we're gonna do that. All right. Y'all hear me? Wake up. All right, let's go ahead and do this. Show these videos. All right, let me put my. All right, guys, let's go. Let's go. Go ahead and pull these these downloads for you guys. Just 1 second. Just bear with me a second, yeah. I need to bring this down for a second so I can show you guys this stuff here. All right, we're going to start with number 27. All right, let's see. All right, let's go. Let's go, good people. Y'all ready? Here we go. Hey, Donna. Hey, love me or leave me. Oh, love me or let me leave. Okay, okay. Love me or let me leave. Okay. All right, let's go, guys. This is from yesterday. I was not here yesterday at court, but we have coverage from yesterday. And today, Thug has on a lighter suit with a black turtleneck. So later on today, I'll show you that video for today. And that in this video here, he has on a like a what is that brown suit, right? What color suit is that? Oh, I heard that yesterday. Okay, I heard yesterday that they told them to evacuate to leave the courtroom. So we should see about that. I don't know what happened, but I heard this is before the judge came in. So this is some good footage. Okay, Young Thug is very talkative today and yesterday. I can hear him talking, right? I don't know what they're saying, but guys, this is from yesterday's footage. Today they're doing Hardship, but I'm not playing today's. I'm playing the one from yesterday. I was not here. But in a few minutes, I think they're gonna have them to leave the courtroom, the attorneys to leave the courtroom. I don't know why. I know a lot of people ask why do they wear headphones in the courtroom. It's because they're listening to the discoveries and stuff like that on the computer or the laptop or the iPad, so they get an opportunity to review their discovery and things like that. you guys have any questions, just put it in the chat. You see them? They're reviewing discovery and things. Part of the evidence in their case. So it's not none of the defendants doing it. You saw they don't have access to it. So the judge, their attorney brings the laptops and the iPads in, so they can review their stuff with them. Hey, Lady Coltrane, how you guys doing? All right, guys, this is from yesterday, on yesterday's coverage of the YSL. I wasn't here yesterday, but here's some of the coverage that went on. Okay, those that are on IG, I'm on YouTube. If you want to come over to YouTube, you'll be able to hear it. It's Infamous Sylvia on YouTube, okay? I just want to let you guys know I'm here and I'm showing the coverage, okay? See you on the YouTube side. Okay, yeah, hold on. Let's go to the next one. Hold on a second. Still got more coverage. Just bear with me as I change this to the next footage. All right, so how you guys doing today? Here we go. He did a lot of clippings for me. And he broke them up into like small pieces. So it could be easier for me to show you guys this footage. So that was number 27. Now we're on number 28. All right, here we go. It's number 28. All right, here we go. Y'all ready? There we go. Here we go. There's this one right here. All righty. Let's go, guys. It's good footage on him right there. He's intensely reading. Whatever he's reading, he has not moved. All right, let's go to the next one. That was a short one. That was a real short one. Let's get another one. I know these clips are very short, but I wasn't here yesterday, so I had to rely on his coverage. But this one, this is when they're kicking people out the courtroom, and I don't know what happened. They kicked all the attorneys out the courtroom. This happened on yesterday. I don't know the details of it, but here it is right here. Can you guys hear me? Can you hear me well? All right, this is them kicking them out. Hold on.
All attorneys, please step up. All attorneys, step up. All attorneys, step up. Please step up. Please. Okay. Hey, Menendez, please grab my phone. Menendez, you talk so fast. Okay, I gotta step up. Okay. I'll worry you something. Yes, sir.
I don't know what happened yesterday, but they were all being told to get out. All the attorneys, they all had to leave. So they even told the camera guys to remove the camera from showing them. So I don't know what happened. Okay, that was that. So then eventually, this is before the judge came into the courtroom. So that was 28. Let me go to the next one just so I'm on a second. He did these clippings really short and small, so it just help us to get some stuff going on. Okay, here we go. Now this is the judge coming into the chambers and get ready to do the roll call. Do you think it has something to do with the leak video? Alexis, no, I don't think so. Thank you for the new subscription. I appreciate you, Alexis. No, I don't think it had anything to do with the video. Um, I don't know, but I can ask around and see what happened. I heard on Atlanta News that they said the judge said that it's being investigated and their bar license could be jeopardy. Yes, definitely, definitely. If you check out my video a couple of days ago, I read the motion that that they submitted, and you can see the footage for what happened at that hearing. When the judge ordered that it's going to be investigation done. So if you go back, the video before this one, you should see it in my feed. You can go and see what the judge said, and it's a live footage of what the judge ordered. Okay. All right. Let me just go ahead on and show this next set of feed here. Just 1 second, and welcome to the all new subscribers. I appreciate you guys being here. All right, here we go.
Lieutenant Gibson, we got everybody.
This where everybody is present, Judge.
Okay, attorneys, we have anybody missing? Check your customary friends you've been sitting next to. Anybody else that's missing or unaccounted for? Okay, all right. Let me go ahead and take roll at this point in time. Mr. Beebe and Mr. Partridge. Good morning.
Guys, remember, this is from yesterday. This is from yesterday.
Mr. Short, good morning, gentlemen. Mr. Farley and Mr. Menendez, good morning. Mr. Williams, Mr. Steele, Mr. Adams, good morning, or gentlemen. Mr. Mender, Ms. Fagan, good morning. Mr. Kendrick and let's see, Ms. Hingerty, good morning. Mr. Huey, Mr. Matthews, good morning. Mr. Myrick and Ms. Bernard, good morning. Mr. Nichols, Ms. Westmoreland, Mr. Garner. All right. Mr. Adams and Ms. Callan, good morning. Mr. Blaylock and Mr. Hill, good morning. Mr. Dorsey and Mr. Jimenez, good morning. Mr. Eppinger and Mr. Johnson, good morning. Mr. Ryan and Mr. Misty Williams, good morning. Okay. All right, councils, let me first give the updates from Ms. Von Kelch. Madam, you want to make your announcements? We did have, you, from pursuant to what you told us, jurors 7:15 to 8:15 who came into this morning. Is that correct, to fill out questionnaires?
Yes, Your Honor.
All right, and is there anybody that we need to account for who did not show up, we otherwise need to track?
Juror 769
Okay,
did not appear. That juror advised my staff on the 24th, following the proceedings, that he was not going to return. And this morning I received an email from him indicating that his wife came into contact with someone with COVID, so he wasn't feeling well.
so did we instruct him to go ahead and take a COVID test and to report that back?
Yes, Your Honor.
All right, just keep track of him, and you can tell him that he needs to update you on that by tomorrow. If we don't, when we're in court, if we don't hear anything from him, I will issue a Rule 9 for his attendance.
Understood, Your Honor.
Okay. As I understand it, how many people did you have that that wish to be examined for hardship today? Or
It's
do a self-examination or their questionnaire?
Sure, it's about 70%. I will get you an actual number.
Okay.
Yesterday's number was 74
Out of
100.
Wow, 74 wants hardship out of the 100.
Okay, and then today you'll be able to give us a total of that later.
Yes, Your Honor.
Okay, all right.
Wow, that's a lot of hardship requested.
Councils, anything else, Ms. Von?
No. Thank you, Your Honor.
Thank you very much as usual. Councils, we're going to go about 15 or 20 minutes. I believe we'll have lunch. It'll be the lunchtime hour, and to accommodate that, and I have an unrelated monthly judges meeting that starts at 12:15, commence and will conclude at 1:45. So that will coincide with our lunchtime hour. We'll work probably from about 2 o'clock this afternoon to a little before 3. I have an obligation at 3 o'clock to take care of. That should take me about 15 minutes, and then we'll work from about 3:15 to about 5 o'clock, and that'll be our work day. At the conclusion of the work day today, I'll let you know about tomorrow. Tomorrow, as you all well know from Ms. Von Kelch, we're going to have jurors 816 to 905 that will be coming in to fill out questionnaires. We're going to have a relatively short work day tomorrow, probably about an hour or a little more than that, due to the fact that we just got, it just takes a little bit of time. We're averaging about 11 o'clock or thereafter for us to be able to get ready. What I'd like to do at that point in time, tomorrow with Ms. Von Kelch's assistance, is to then just map out over the next probably week and a half, the dates that we will be examining those jurors, the remaining jurors for hardship, and we'll schedule those accordingly. So, any ministerial inquiry before we get started? All right. Mr. Randolph, can we start off with 774? I believe that person has an affidavit. Is that correct?
Yes, Your Honor.
All right, 774, councils.
All right, that's that clip. Let's see. I think he had. I don't know, because the next one is going to be like jury boring stuff, and I don't want to play that. Let's see what else I have here. Since Alexis has not been here, Alexis, did you want me to go ahead and play the from the other day? I don't know if I have it here. I might have it from the other day. The hearing from the other day. If you do, you want? Yeah, I do have it. Do you want me to play that one so you can see what the judge said? I know a lot of people have already heard it, not you, but I'm willing to play it for you if you want me to. Okay, I'll do it for you because to kill some time. Because the other stuff that I have here is just basically let me just see what else he has here. I don't want to play the juror stuff because that's pretty boring. Hold on a second. Let me see if I have another couple of clips and see if it. Hold on a second. 29. Let's see if 29 has something. That was. Okay, let's see. 32. He has some good footage of their faces. But let me just play this one here. This one's going to be a short one here. It's just footage of the defendant in the courtroom. Hold on a second. Let me just play this one and I'll play the other one. Yes, Crushy. You know, the other guy came in after this case and this case is over, got a verdict and everything. They're about to be sentencing him, right? It's crazy.
Several bases for hardship. One of them is a medical, where you have an affidavit. You got, I guess.
I'm going to mute this part, okay? Yeah, I'm gonna mute this. I'm gonna mute this part because they're doing the hardship. So I'm just gonna mute the hardship part. Okay. No, I know you can hear it because he doesn't show them. He doesn't show the juror, so it's good. He doesn't show the juror, so this one is okay. But the other ones, this is like boring. Let me go ahead on and do the other stuff. Just one second, guys. I'm pulling up the video for Alexis. She wasn't here. Let me put it on the disc so I can play it for her. And this is from the other day. I know a couple of few people have not seen it, and that's what I'm playing it for you guys. One second. All right. All right. I'm going to go ahead and play it so Alexis could see it. You guys just bear with us for a second. Bear with me as I play it because a lot of people have not seen it. So, all right. Thank you, guys. All right. Let's go. Oh, you're welcome. Okay. Here we go. This is from the other day's hearing when the judge is discussing the leak, okay? And his decision on what he's going to do. Hold on.
The state's motion for an order reinforcing the court's directive prohibiting dissemination of discovery pursuant to OCGA 17-16-4 Delta. And then the response to the state's motion for an order reinforcing the court's directive pursuant to that same code section, OCGA 17-6-4D. Let me recap what is alleged. And Ms. Bernard, you can certainly augment this, but I'm just going to put for the purposes of the record just what's been filed so I can rule upon it. Honor about order
Can y'all still hear it
specifically
with me
restricting
muting it?
the disclosure. Discovery with non-members of the
Okay, now go.
defense team. Defense
Go ahead.
counsel may meet with potential
Sorry
witnesses
about
and
that.
show
Sorry about
discovery
it.
information to those potential witnesses as needed, but the defense counsel must prohibit those witnesses from recording, photographing, taking notes, or receiving a copy of any discovery materials. All parties, paragraph 5, are prohibited from sharing discovery material with any news media sources, social media, or other public forums. It has come to the court's attention through Ms. Bernard's motion and the state's motion that on or about February the 17th, some discovery material was disseminated on social media in clear violation of this order. That was apparently a witness interview of somebody that is going to be called potentially at trial. That particular video has garnered some over 30 million views on social media as of yet, and probably counting. And that would be in direct violation of this court's order. Now, you all in this courtroom are very seasoned advocates. And without I don't want to necessarily get into down in the eaches as to what or who might have disclosed this particular information, because I can't do that right now. And certainly it affects everyone's right to a fair trial under our U.S. as well as our Georgia constitutions, particularly the 5th and 6th Amendments in particular. But I want to just remind everybody about their obligations under those who are lawyers and who supervise paralegals and other support staff. Under Rule 1.6, which many of you probably not looked at it at 30 or more years, some of you that have been practicing that long, or varying lengths of time since you took the ethics course and passed the MPRE. That's the bedrock of our profession is confidentiality. And we're supposed to keep confidential information close and be close hold. So many of the things that we learn from representation, we can't share with anybody. This is just a prime example of a potential disclosure in violation of 1.6. Now, I don't know who did this, but if this pertains to you, then please kind of just amend your ways and kind of just think about how you keep information safe and who you're sharing it with, because you're playing a very dangerous game with your 6-digit bar number. Because one of the things I will do as a result of this disclosure is I will go ahead and order an investigation. And I'll tell you that the computer forensics folks are really good these days at finding the source of people's disclosure. So that's later, and I'm not going to take that up now because that's not something I'm equipped to do, but I am going to order an investigation in terms of that because my orders to you all are not aspirational. They're for the purpose so that everybody gets a fair trial. So if you think you might have leaked this particular information because you could tank your buddy or tank somebody else's ability to to have a fair trial, that would just be wrong on all levels. Like I said, I don't know. I'm not casting aspersions on anybody because I don't know who did it. But I'm just reminding you of your obligations as professional advocates to play by the rules. The rules are designed so that, especially the rules of ethics and the rules of discovery in this particular case, so that people can be protected, people can have a fair trial, people can have a lawful trial. And that's the only reason for it. And for this to have occurred and for me to have to deal with this at this point in time in the trial is just unacceptable. So I want you all to think about that. So Ms. Love, if you'll prepare a suitable order for my signature to an order of investigation, I will go ahead and do that. And as a result of this particular disclosure, this is the last time I'm going to have a conversation about this. If I have another conversation about the disclosure of information, then you're only going to get it from my chambers, either in the courtroom or in the jury room. I'm going to restrict it to that particular area for it to be looked at, because I can control that. So, as I said, this is not, and Ms. Bernard, thank you for bringing this to my attention. I'm sure that it would have probably come to my attention otherwise. At this point in time, Madam, however, I'm going to deny your motion for mistrial. However, I will permit you and your colleagues, as appropriate, as people come in, both sides, to ask them if they have heard about this video and if that affects their ability to be fair and impartial to your particular client or his or her interests, okay?
Yes, Your Honor, I'd just like to add, I appreciate everything that you said. The one thing that I would like to stress, when you were talking about what you were talking about just now, it felt like you were blaming the defense.
I'm blaming everybody. I'm not blaming, like I said, I can't determine who's doing this. You wrote that in your motion, madam. And I'm not casting aspersions. I'm not blaming you, and you did that in your reply to the state's motion. This is something that affects all of us. And until I find out, or if I ever find out who it is that did it, then I'll have that conversation with that person. But I'm reminding everybody, all sides, that this is something that is a joint responsibility to adhere to. 1.6 is the bedrock of what we believe and what we do as lawyers. We safeguard people's business and their secrets and their confidences, and we don't disclose them, even though it might be satiating and interesting and get other particular, be newsworthy. It's just not. And the reason that we signed this order, both sides asked me to sign this order, is because of the fact that we need to be able to safeguard information and individuals. That's why I did it. And that's why I'm kind of annoyed that the whole thing, that somebody just decided, hey, forget what the judge ordered. I'm going to just go ahead and release this. So, madam, to your point, okay?
All right, thank you, Judge. And depending on the outcome of the investigation, I may renew my motion.
Yes, ma'am. That certainly would be within your purview, if in fact I get it, whenever I get that done. Yes, Mr. Matthews.
Can we ask that the court reflect the order that this is a joint request by both the government and the defense? Because I think we're all interested in terms of this, not just the government.
No, it's going to be my investigation. It's going to come from me.
Okay.
It's not going to come from any particular side. It's going to come from me, because it's my order that somebody violated.
And also, it's not going to, I'm sorry. And also, are you also saying that you're denying the state's motion to restrict our obtaining of discovery at this point?
Yeah, but if I have one more disclosure, you're going to get restricted. Your restriction is going to be not their office, my office.
Understood.
I would presume that will be after the investigation determined how it's going.
One thing at a time. I need to first sign the order, and then I need to kind of figure out where we go from there. That'll be something that I'll go ahead and let you know as it becomes appropriate. Okay? Yes, Mr. Jimenez.
On your rule now, so you say that we ask today is the time for us to let you know why their request shouldn't be granted. You're letting us know today that if there's another leak, wherever it comes from, we will be restricted.
I hadn't decided that yet, but that is one of the things that I potentially could do, because if I can't control who leaked it at that point in time, if there's another particular incident, I'm going to have to relook this particular issue.
Well, I find it necessary to bring up some issues as to the way discovery is being brought, and I also feel like I need to address this because it is under motion, specifically Section 2, where they seem to allude.
But you all have a duty as advocates to me, not me personally, you're a Glenville, but to the profession and the bench to adhere to the rules. So it doesn't make a difference who raised it. The state raised it, you could have raised it. Ms. Bernard, did raise it. She was the first person to raise this under an issue of, she just moved for mistrial. But so it doesn't make a difference who makes the motion.
No, that's not what I'm trying to say, Your Honor. What I'm trying to say is that in their motion, they are specifically complaining that this leak happened after the defense.
But I can't determine that. I'm not going to determine that today.
So I just want to.
Can you just wait till I do the investigation? And then, that's why I didn't get into all of that was put in the motion. We're not going to. It doesn't behoove your clients for us to discuss all that right now. It affects their ability to get a fair trial and lawful trial. Just let me go ahead and do the investigation at this point, and then we can revisit this other who may be responsible at another time. It's just allegation and assertion at this point in time. So all you be doing is asserting some other position, and right now it's not the position's not important to the court. What's important to the court is a disclosure has occurred. It's been noted to me, and I'm not happy with it because somebody violated my order. That's the bottom line.
That's not what I'm trying to say, Your Honor. If I may just finish. What I'm trying to say is I think as a group we have all identified a possible flaw with the way discovery is being released, and if I can express it to the court, maybe we can address that to prevent any future disclosures, whether they are intentional or not.
Well, I hope they're not intentional, because intentional will get you in a lot of hot water with me.
I can assure you it's not me. It would not get me in the hot water because I am not disclosing anything. There is no staff. You're looking at the secretary, the executive, the senior. Everything in my firm is done through me. And I can assure you there's been no leaks from the Chada Jimenez office. However, the state is providing discovery through an unsecured Dropbox link. Anybody with access to that link has access to the discovery. It's not even password protected, Your Honor. That is just the bare minimum for something that has a level of confidentiality to adhere by Rule 1.6. My discovery, as I requested and as they're complaining, is right here. This is my discovery. And I invite the state, look at it. You can't get into it without my fingerprint because I asked for it on a thumb drive, on a hard drive, so we don't have that issue. I am just saying, we are asking that if the state has any future discovery, give it to us in a secure form as a hard drive. That way, I have it in my possession, not as a Dropbox link.
I don't have an issue with that if you provide the state with the drives.
Of course, I provided them that,
well,
but
that's a suggestion, certainly.
Yeah, because I definitely do not want to be restricted. I think we need access to the discovery, especially I don't want to be restricted if somebody else, whether it was from the defense or the state or some rogue officer or somebody that in the internet feels very passionate about this case and wants to start digging, the Dropbox is not secure. We need to do a better way. This is not new. This is just, even a password being assigned to that Dropbox link would have been the bare minimum. And this is the state providing the discovery. I just wanted to bring that to the court's attention. I'm not here to blame anybody. None of us benefit from the leaks of anything.
And I appreciate that suggestion. That is a good one. And I think I will incorporate that for future discovery exchanges. Okay.
Thank you, Your Honor.
All right. Anybody else? Any other defense attorneys, I should say? Madam, Ms. Love.
Thank you, Your Honor. And I appreciate Your Honor addressing the matter of having an investigation into this. Your Honor, I wanted to point out in response to Mr. Chada's suggestion to the court regarding providing discovery on a medium to counsel for the defendants. The issue, I believe, originally was that they were unable to download videos and the like. And for the entirety of a year, I guess, that they had been receiving discovery via that Dropbox link that they could not download from. This type of thing had not happened to this extent. It was only after the court instructed and we followed the court's directive to place videos on that type of medium that 20 days later or so, this leak occurred. Your Honor, we will of course abide by whatever instruction and directive that the court gives to the state. But we also have in mind a more secure method of transmitting discovery to the defendants, which will require any person who downloads or looks at that to have a password and a marker will be placed on that item that they look at. Now, we can't prevent unlawful cell phones from capturing those things as they are viewed. But, Your Honor, we'd ask that the court allow us to endeavor to provide future discovery in this method that will at least place a watermark on the pieces of evidence that we provide to the defense.
I think placing a watermark on what you have is a separate issue, and that might not be a bad idea for it to occur, because then if it's transmitted, you know where at least that was what you got from the particular discovery that was in fact it's made of record. It's not a bootleg, but I do believe Mr. Chowd's suggestion of a drive being presented to you all, given to you so that it may be copied and they can, everybody has it can be protected by biometrics or password.
Question. Let's see your words right here. Look.
Move to that at
See?
this point in time. So that's what I would.
You're okay.
I would ask that both of those two things be incorporated at this point in time from going forward. Okay.
And yes, Your Honor. And to be clear, the method that I was speaking of is evidence.com, which is the evidence holder for that the county uses that is secure, that we can send out discovery to the by way of.
Okay. Yes, Mr. Jimenez.
I just want to clarify. At no point, I requested the hard drives. At no
I'm sorry,
point.
no point. You what? Sorry.
Did I say I couldn't download it? I said it was too burdensome to download what it ended up being 2 terabytes. I have to download 1 file at a time. So I requested that they put it in a hard drive.
I remember us having that conversation already.
Yes,
Okay,
I-
That
Alex.
issue.
It's
So.
just the state said that we claim we
Thank
couldn't
you.
download it, and then after.
No. Look, let's not replow that road. I understand, and I certainly, the court concurs with you in terms of, I think Mr. Matthews also brought that up earlier about not being able to view that. If it's on a drive, it's a lot easier for you to move it around and take it and show your clients. So, that makes sense. And I certainly think that would be appropriate. The issue becomes, again, keeping the confidentiality of the data that you're given or entrusted. It's not to be shared with the people outside of in this order. We're not trying to prohibit, the court is in no way trying to prohibit you from utilizing it to prepare and otherwise show to those parties that you necessarily have to, but it just can't go on social media wholesale like this particular interview did. So again, please don't do that. I really don't want to have an uncomfortable conversation with any one of you, but I will go ahead and have this ordered, have this investigated. And I'll keep you all posted on that particular issue as we go forward. Anybody else wish to be heard on that issue before I go ahead and move on to any other ministerial acts, and then we talk about hardships for the afternoon.
Your Honor, and I do want to be clear so that we can make certain to abide by all of the court's instructions. With respect to the dissemination of discovery from this point forward, the state, of course, will be utilizing evidence.com as it relates to the downloading of materials to terabyte drives and the like. What is the court's instruction to the state and to the defense? Are they to give us something?
Yes, they're to provide you the appropriate terabyte drives for you for that material that's subject to being disclosed for discovery to be put on those drives in working order so it can be read or otherwise manipulated for their use.
Understood. Yes, Your Honor. I see clarification.
What's your question, sir?
Are the existing Dropbox links going to remain open, or are we?
I recommend you terminate those. I recommend you move them to another space and place so that you can, or at least if it's not been password protected or otherwise enhanced in terms of security, that you do so.
Your Honor, and with respect to those links, each attorney has the ability to download from that link, and then
Why do we keep going back to this download? The downloads have been a problem. The reason the downloads are a problem because of the size of the material you have. So I think that you're going to have to move away from that, Ms. Love. It's just too much. It's easier just to copy for their particular reason, since you've got videos and other things, to go ahead and just copy them onto a series of terabyte drives. Then they're portable. So I would just direct you to do that. Mr. Steele, do you have an inquiry or a comment?
While
You're next, Mr. Matthews. Hold on. While you're what? I'm sorry.
we're talking about this, and the state will tell me, can you also put in your order, you consider when we will have all discovered? Can you put a date on it, or as a state, I keep getting discovered and it changes?
Well, of course, you have a continuing obligation to disclose discovery. I would just say that, the state needs to disclose that within, have you given all the discovery already, madam?
we have
Or 95% of it?
that we have, and as we collect it, we send it out. We endeavor to have collected and identified all that is identifiable by the April 28th date that the court alluded to earlier. If the court instructs us otherwise, then we will continue to disclose discovery throughout, because we recognize our ongoing obligations.
The reason I ask is because the state of Georgia is giving us discovery last month. They had it in October 2022, 2021. So it just seems like they have the discovery. I just want, it takes a lot out of us to get ready, and then it changes.
Sure. One of the things I might recommend you all do is just on a weekly basis that you or members of the defense, individually or collectively, a representative from the state can make sure
No,
that
waiting
you
for
update your
Tony because
discovery.
he has
That
something
might be
he
the
has to
thing.
give me.
I can order
Huh?
that to occur.
Oh, okay.
At least you have a
Yeah.
conversation. Is there
Hold on,
anything
okay.
else
I said, Tony, where are you?
need
Because it left already.
during the week that you do that, or so that we can, so you can make sure that at least up to that point you have everything you need.
Yeah,
So
he
I'll
was
direct
found
you to do
guilty.
that on a weekly basis, starting this week. You can pick whatever time you want. I'll leave that up to you all as professional advocates, and go ahead and take care of that. Mr. Matthews.
So, but there was a quick verdict. That they didn't review anything.
Do I think there's a possibility of doubt here? Because first of all, I think it was talked about for so long,
And they had that video. They had not the video. They had that documentary on. You cannot have a fair trial and you keep putting stuff. Exactly, that's not fair.
Ms. Love, just if you do have something open, you have 10 days, okay, from today's date to go ahead and download anything that is not otherwise onto an appropriate drive. And if you're not able to do that, then the state, you provide those drives to the state so that they can go ahead and facilitate that download, and you don't lose that information, okay?
The family didn't get any.
Yes, Mr.
So a lot
Jimenez.
of people were out in blood, they were kind of like the center of the whole community.
And
But
just,
they had money, just like
Sudi
Judge
Chakimans on behalf of Mr.
Newman
Dorsey.
said. He said they had to take
And
his grandfather.
To reiterate what
They
Governor
got a
Brown Steele
picture
was saying,
of his
I think
grandfather
the issue that we're trying
in
to
the
get at is
courtroom. They had to
not
take it down.
ongoing discovery, newly discovered discovery, new post things new
So
to that.
this
That's
family
fair game,
has
but
been around.
I am requesting.
But
that
he gonna
there
put
is
the
a
picture
deadline
back up
for
after this.
Yeah,
Right?
they
Okay.
gonna have to.
discovery.
Because I was like, that
Because it should
ain't
be
got
10
nothing to do
days
with the
before trial.
grandfather.
No,
And I get
that's
it that
not.
there's a
The
lot,
rest
and I
of
get
them
it that there's a
I
lot
mean,
of
you know, when he
agencies.
took it down,
However,
but he should have left
for
it up because he
example,
didn't have
this
anything to
video,
do with
I think it came
that.
back
You know,
in
he
the
really
link
didn't.
9
He had nothing to do with that.
from the Dropbox that this video was
You
in,
broke in?
and they've had it
Oh,
for
no,
years.
you ran
It
in.
is not newly discovered.
We'll see. I think a lot of
It's
stuff
in the
gonna come
possession
out
of
of
got
them
me.
or law enforcement. It's
Okay.
deemed to be in the possession of the state, and we should have had it 10 days before
All right.
January 9th. That's all we're asking. New discovery, yes. If I got discovery to turn over that comes up since then, I'll get it to them in a timely fashion. But old discovery that already exists and is in their possession, we're
Yeah,
asking for it to be
I'ma
turned
lock
over
it up.
by a date certain, and if not, to
Yeah.
be excluded.
Here's what I'm gonna do. I'm gonna direct, because we're gonna be, I think, have some days that are down
Monday.
next week,
I'll see you Monday.
due to some unrelated business that the court has.
Hold on a second.
I'm gonna
playing
direct
this
that
for them.
you
Hold
all
on.
meet on the 7th and 8th
Yeah,
of March
from the other day.
to have a discovery conference and see if you can resolve
No,
any and
no,
all
this is
discovery
from
issues that may be outstanding. And then you can report back to the court. We'll pick up on the 9th and we can report back. You can tell me what you think is missing. But I'm gonna direct all counsel to that is the state's counsel and the defense counsel on the 7th and the 8th of March to meet. You can meet in my courtroom in 8F, and you all can have individual or collective conferences to make sure that you have everything you need, okay?
And Your Honor, with respect to that date,
Your clients will not be brought over for that date. It'll be attorneys, it'll be just to the purposes of discovery for that, okay?
as there are things that we are requesting and have.
Okay, guys, I'm gonna have
requested
to
from entities,
end this
I would
because
ask
hold on a
courts,
second.
To be allowed to inform defense counsel of those items and to,
Okay.
commit to
Several
having that
basis for hardship. One of them is
no later than April the 28th, because there are things that we are aware of that we are waiting.
well, I think you need to tell them that. I mean, in the interest of full disclosure, I think that fosters just one, your responsibilities, and two, you're not playing ball, hide the ball with them. You're just telling them, hey, listen,
Okay, guys, I have to end this because I have to get the footage for today. So, I'm gonna have to end. You guys have an awesome day. I'll be back later on to give you guys footage from earlier today, and get those likes up, or else you're not gonna get anything later on. All right. Shout out to my cameraman. He got my stuff for me. Tony's in the house. All right, guys. I'll see you guys later. Bye bye.